brought in 2021 to provide basically the options as to what options in this have. So if you want that time, just
I don't need to keep zooming.
I do 45 minutes every day.
I just have to end the meeting.
Yeah.
That's right. Yeah. Thanks for taking that.
Thank you.
Okay. Moving along.
Can I explain all that?
Yeah, sure.
There is a reason.
Okay, everybody, welcome everybody to our short-term rental committee meeting. I'd like to advise everybody that we are being recorded and live streamed, and our participants joining us from the council chambers is actually, I'm going to call for a roll call, sorry, first. Our committee member, Richard Clark. Present. Thank you. Committee member Suzanne Kors.
Present.
Nina Janosik, is she with us on live stream?
Yep. I'm here online.
Welcome. Committee member Dave Conk, I believe. Tosh, sorry. Is Dave with us? Okay. Jeff Martin. Present. Committee member Doug Owens. Present. Thank you. And our staff, Ellen Arthurs. Our planner via Zoom, Christina Coulter. And our administrative assistant, Kara Lumber. Thank you. And also our guest presence today, we have Ajay Garcia. Well, thanks. Present. With a quorum of committee in attendance, I would call the meeting to order. We will now have our land acknowledgement. We respectfully acknowledge that we are on the treaty and traditional territory of the Mississauga Anakivish. And where's the end of that ball? And oh, sorry.
It's on the next page.
Sorry, I'm stuck on the pages there. Apologize.
Take this one.
Sorry. We offer our gratitude to the First Peoples for their care for and teachings about our earth and our relations. May we honor these teachings. Okay. Also, I'm going to ask for disclosure of pecuniary interest. If anybody has a disclosure of pecuniary interest, please advise us, or anytime throughout the meeting, please advise us that you have pecuniary interest. Seeing no hands, we will move on. Now we'll ask for a mover and a seconder to approve the agenda of May 18th, 2023. I'll move. Jeff, seconder. Suzanne. All in favor? Are there any additions to the agenda? Seeing nobody live stream, or only if somebody puts their hand up right there. Okay. Seeing no additions, I'll call for the motion. All in favor? Carried. Okay. Okay, adoption of the minutes and business arising from the minutes from our February 22nd meeting. I'll ask for a motion And a seconder for to receive the minutes. Motion. That's Jeff, seconder.
Second.
Doug, all in favor? Carried. Okay, a proposed timeline for the committee report to council. I'm going to turn this over to Alana and let Alana speak to that.
Thank you, Deputy Mayor. I know we had some discussion about the original terms of reference and the expectation from council and trying to meet those timelines. So I thought I would just take the opportunity to sort of talk about this meeting today and what the hope was coming out of this meeting and how quickly staff might be able to come back so that the committee can then make a presentation or recommendation to council. We will hear from our planner today as well as the solicitor, who will outline some options on how we can govern short-term rentals, if that's what the committee chooses to do. I think following that, we can have some discussions about those options and the feeling of this committee and what direction they want to go in. Once we have a consensus of the items we want to look at, staff will go back and we will come back to the committee with a further report once we've been able to do some research. So once we go through those options, we'll come back and talk to the committee about, what staff have put together. For example, if it's a licensing model, we'll come back with some information. If the committee is satisfied with what we provide, then we have a path moving forward to council. So we do have at the end of the meeting, the opportunity to set the next date. I am expecting it will take some time for staff to research whatever the committee decides. Likely we will come back in July and August for our next meeting. If we have to do some additional research and come back again, I think we will probably do that by September and have something to council either in September or October. So we're not too far off of the timelines as established. But once we get down to kind of discussion at the committee level on what you would like to see come forward, and we get an understanding of how much work that is for staff, we'll establish our next meeting and try to move through as quickly as we can.
Good. Thanks, Lynn. Delegations, we have Christina here, our planner, to discuss with us. And without further ado, I will turn it over to Christina. Thanks, Christina.
Thank you, Chair. I think Tara is going to share. I have a small PowerPoint presentation. Or if I can share mine, if that works better, maybe.
That would be great.
Okay, let me try that. I saw the looks, so I was trying to read into.
Yes, she's a co-host. Okay.
Give me a second, and sorry for this. Everyone see that? Give it a few minutes. Can you see? I'm just waiting for a nod. Yes?
Yes.
Okay.
100%.
Okay, so I'm going to try to, I might not be looking at the screen because I've got it on a separate one, but I will, I'll try to click and move forward because this is just it's right from the agenda. Excuse me. So thank you, Chair and committee members. So I'm Christina Coulter. I'm the planner for the Township of Douro-Dummer. And I've been asked to provide the committee with a review of the Township official plan and zoning bylaw as it relates to short-term rentals, which are also referred to as short-term accommodations. So for simplicity, I'll reference these as STRs or STAs throughout the presentation. So the governing official plan for the township is the County of Peterborough official plan. The official plan was developed in 1994 and has had numerous amendments since that time. Short-term rentals are a recently new phenomenon, and they are not currently defined in the official plan. There are also no specific policies regulating this type of use. Broadly speaking, section 4.6.3.3 of the plan addresses the tourism sector, and it contains general policies such as encouraging local municipalities to designate lands for tourism uses in their OPs and to direct new tourism development to areas that will support and complement existing tourist facilities. The plan encourages complementary tourism development in downtowns and main streets, and it promotes compatible on-farm agritourism activities with criteria similar to those set out in section 4.6.3.4 of the plan, which relates to on-farm diversification. On June 29th, 2022, the County of Peterborough adopted a new official plan. The new plan is waiting final approval by the Ministry of Municipal Affairs and Housing. STAs are specifically referenced in section 5.7.3 of the new official plan. And that section states that local municipalities may regulate STAs through local zoning or municipal bylaw as appropriate for their community. Section 5.7.3 of the plan is located within section 5.7, which addresses employment and economy. Generally speaking, employment and economic activities are directed to settlement areas that are serviced with full municipal services. However, other locations in countryside designations may be considered where they meet certain criteria, for example, larger sites, compatibility, proximity to resources, and servicing. So once the new official plan is approved, the township is required to update our zoning bylaw. The current township comprehensive zoning bylaw is bylaw number 10-1996. This bylaw was created in 1996 and had a major overhaul in 2000 when it consolidated the township of Douro and the township of Dummer into one document. Since that time, there have been various amendments to the bylaw. However, as it relates to STRs, the bylaw contains two definitions. So the first definition is rental cabin or rental cottage. And this means a tourist establishment designed to accommodate one family in a detached building or in one of two such buildings which have a common wall. The second definition in the bylaw is the definition of tourist establishment, which means a building or area designed or used for the accommodation of the traveling or vacationing public, and it shall include a lodge, motel, rental cabin, or rental cottage, both of which are defined above. So in our existing zoning bylaw, a tourist establishment is permitted as of right in the commercial tourist zone. And that is 12.1.7 of the existing bylaw. So as of right means you don't need a rezoning to permit it in that designation. It's permitted, but it must comply with the regulations that are set out in section 12.1.7 of the bylaw. So for example, the property must have a minimum lot area of 4,000 square meters, which is just under an acre in size. It must have a minimum lot frontage of 100 meters or 328 feet. And the building or buildings must comply with the applicable yard setbacks, lot coverage, and maximum building height requirements. In addition to those criteria, rental cabins must also comply with section 12.2.2.1 of the bylaw. And this essentially sets out the minimum and maximum floor area for the rental cabin. So in addition to the, I was just going to say before I go into this next zone, there was a slide that was inadvertently removed, but the slide indicated that a tourist establishment must also comply with section 12.3 of the bylaw, and that outlines planting strip requirements in accordance with section 332 of the bylaw, and it also must comply with the applicable provisions of section 3 of our zoning bylaw, which are the general zone provisions. So in addition to the commercial tourist zone, a rental cabin is specifically permitted in the special district 229 zone. The use of the rental cabin on this particular property is subject to the special provisions which are outlined in section 21-229.2 of the bylaws. So just as a quick summary, there are 10 properties within the township that are currently zoned to permit either a tourist establishment or a rental cabin. And the map on the right is just an example from the County of Peterborough GIS, which illustrates 2 properties in the township that are presently zoned to permit those types of uses. So that is my quick presentation. If anyone has any questions, I'm pleased to answer them, and I'll turn it back to the chair.
Thank you very much, Christina. Does anyone have any questions for Christina?
I've got one observation, Christina. In the county official plan, you referred to short-term rentals. Did you read the first draft of the county official plan? Where it had wording to the effect that after short-term rentals, having regard to the economic benefit to the community. Those are paraphrasing rough words. Those words were specifically deleted. I challenged the county planner to approve a study, approve a provincial policy that there's an economic benefit, and he agreed he couldn't support that statement. That was deleted. Are you aware of that?
So thank you, through the chair. I did participate in the new county official plan, but I was working for another municipality at the time. And in that municipality, short-term rentals are not presently permitted. So I would say that I'm not aware of the specific request to have the wording removed.
Well, it was removed in recognition there is no empirical evidence that they generate any tourist money for the local municipality. So I just want to point that out.
Thank you.
Okay. Thank you. Moving on.
I think there's one more.
Sorry. Oh, sorry.
Sorry. I just wondered if there was any restrictions on waterfront residential as far as what activities you can have on those residential lots, yeah, when they're waterfront. Are there any restrictions?
So just through you, Chair, to confirm, right now, in the present bylaw, the only zones that short-term rental would be permitted in would be the commercial tourist zones, which wouldn't typically be a strictly residential property. Those would be properties that are designed and developed for tourist accommodation.
Thank you.
Okay. I'd like to just go back and ask if Dave Cook is with us on live Zoom. No, is he on Zoom? I thought that he was present, so my apologies.
There's nobody in the waiting room.
Okay, if we can have that on the record that he is absent, please. Okay, thanks for pointing that out. Okay, if there's no more questions for Christina anymore, I don't see any show of hands. So show of hands for Christina, if we can move on then. And I'm going to turn it over to AJ from Aird and Burlesque. If AJ would like to do his presentation.
Thank you, sir. In light of the comments given at the previous meeting, I wasn't intending to provide an overview again of the different tools in the toolbox, but I did provide a redacted version of the opinion that went to council in closed session with a number of notable or small updates. At the time of drafting that opinion, a critical case is the Oro-Medonte experience. And at the time of the initial opinion, there was an oral decision of member Vincent of the tribunal with respect to the modification to Oro-Medonte's zoning bylaw approach. So the original opinion had a summary of the oral decision notes because our firm happened to acts for Oro-Medonte. So I had the notes about what the oral decision would be. Following the opinion, the written decision came out. So I've updated the document with the written decision commentary from member Vincent, providing further guidance. Unfortunately, the tribunal in that decision didn't provide the really determinative guidance that would be very useful for us here and for all other municipalities in Ontario. Member Vincent noted in the written decision where she denied the modification to the zoning bylaw approach. In her decision, she said essentially Oro-Medonte's position is that its existing zoning bylaw was sufficient to enforce against commercial operations. But then member Vincent doesn't go far enough to say, I agree with that, or I do not agree with that proposition put forward by Oro-Medonte. I can further advise to the written document that there is a leave underway with respect to the Oro-Medonte case. And so that is still to be determined, as well as there are enforcement cases going forward in Oro-Medonte with respect to the existing bylaw, and we don't have the determinations arising from those yet either. But in a summary sense, my role, as I understand it, is to assist the community in advising of the various tools in the toolbox available to you for regulating the issue. And that's the will of the committee and eventually the will of council of the form of that regulatory approach, whether it be solely through zoning, the official plan, land use planning policies, or it's that approach in conjunction with a series of amendments or strengthening of regulatory bylaws, noise, nuisance that deal with the adverse effects arising from not just short-term rentals, but all properties, waterfront or otherwise, that could deal with some of the negative effects for traffic, for noise, for disruption, for nuisance, dealing with that in a regulatory approach. I also addressed in the written document and some of the comments that licensing is an approach taken by municipalities. And in addition, it's more of an aside, but there always is a civil common law remedy where individual neighbors can make a claim with respect to nuisance, albeit that as a significant cost hurdle for the individual owner to pursue something like that with adjacent or neighboring properties. And I did want to note one very recent development nationally that hasn't yet come to Ontario, but there's been the experience in Quebec where this is a national problem. All municipalities sort of across Canada, we talk about this at the Canadian Bar Association municipal section all the time, that short-term rental regulation is a present problem for municipalities across Ontario, in BC, in Ontario, and in Quebec. And Montreal happens to have some of the strongest municipal regulatory provisions with respect to short-term rentals, but there were still incidents that occurred, most notably a large fire in the Old Port in the city of Montreal. And as a result, the province of Quebec is proposing its own regulations and its own regulatory regime to deal with short-term rentals, to take some of the pressure off municipalities in Quebec in dealing with it. And there's been some news coverage that might come to Ontario and British Columbia as the two provinces in Canada that also grapple with the issue most heavily across the country. But there's nothing there yet for Ontario and for BC, but I did want to flag that as another recent development. So there may be a provincial layer to this that we haven't discussed at all previously. It's not really before the committee, but it's just something to be aware of in terms of changes nationally that might assist in the go forward scenario. But I sought in the document to lay out a number of the regulatory approaches, how those could be constructed, some of the pitfalls. And each of those don't necessarily have to be done in isolation. They can be done in conjunction if that is the will of the committee and again, the will of council. There are also factors that are outside of the legal ambit that have to do with costs and the expense related to each of those regulatory approaches. So that is something to be considered by the committee as well as by council in terms of what approach the municipality would like to take. So though I tried to lay out some of the options, I'm here and I'm happy to answer further questions. And I gave a bit of the overview at the last meeting, and I do think it is helpful for everyone to have a copy of the document. And as Alana noted, the redactions are solely for the purpose of, we try to take out anything that is, we always include opinions and documents. Well, here's what you could argue if you put forward this regulatory approach, and here's what someone could utilize to undermine that approach in legal argument. So all of that has been redacted because we don't want that for the municipal community. Basically the stick that could be used to beat you with if you go forward with a particular type of regulatory approach. So to Alana's point, there wasn't an intention to remove anything material. It's really just the elements that could be used to criticize or challenge any of the types of regulatory approaches. And we would want to go into a bit more detail with the municipality, depending on which way the committee goes in terms of the suite of options to regulate and look into each of those approaches in a bit more of a granular, finer detail. But we sought to give a bit of an overview of again, the tools in the toolbox.
Okay, thank you very much, AJ. If I could have a mover and a seconder for Christina's presentation. Second. Okay, all in favor? That's carried. And if I could have a mover and a seconder for AJ's presentation.
May we ask AJ questions?
Oh, sorry. Sure, let's get the mover and seconder first, and then we can ask.
Okay.
Okay.
No.
And now we can go ahead and ask AJ for questions.
AJ, thank you for your guidance, and this is very helpful because it is a difficult topic, and even I recognize it's hard to decipher it all. The first observation I made from the Quebec proposed legislation, I don't know if you paid attention to the name of it, but if my memory serves me correctly, it's an act to regulate illegal tourist establishments. So the act itself in Quebec describes these things as illegal. So I just want to point that out to the committee. Okay. Secondly, when you refer to the McGill author quoted in the commentary, he also expands his commentary and points out across Canada that STRs are causing part of our national housing problem. He estimated in 2019 that a minimum of 33,000 units have been taken out of the rental market long-term and put in the short-term rental market. So we've got a national housing problem, and I'm pointing out short-term rentals are exacerbating our national housing problem.
Okay, that's great. That's your opinion, and
No, that's a quoted opinion from the McGill professor that's examined this right across Canada in 2019.
If you could bring that forward to us in the article and quote it properly.
I provided this to Alana and asked her to put on the agenda for the next meeting. And the backup studies are all there.
Biased, I'm sure.
please go through the chair, folks. Please go through the chair. Anyways, thanks for that. Thanks for bringing that information to us. If you can bring us any more information back in that, That's all fine. We'll take a look at that, Doug. Anyways, as AJ has said, there's nothing official in Quebec that we know of. Is that correct, AJ?
No, there is proposed legislation in Quebec that is official. There is nothing in Ontario or British Columbia yet at this time.
Has that been passed though in Quebec, AJ?
I don't think it's been passed yet, but it is proposed by the governing party, so it's likely that it will be passed. It's more of a comment of what could occur in Ontario, because regardless of what gets passed in Quebec is not germane or directly applicable to the regulatory context in Ontario. It is just a note of the broader macro legislative developments in Canada.
Great. Thanks, AJ, for making that clear. Anyways, did we get a motion of all in favor of AJ's?
No,
I think
we haven't.
so is there any other questions for AJ on that particular topics? Any other questions?
Can I ask one more? AJ, other than the Ottawa condominium case, where the judge in that case defined short-term rentals because of the nature of credit card payments, strangers, that's the only provincial case that I came across. And that judge clearly defined short-term rentals as a commercial use. Is that the law of the province right now? Because that hasn't been appealed or overturned, or as far as you know?
So I can step back, Doug. I can mention one comment in addition to your previous comment with respect to the housing crisis and that housing supply considerations. I will note that in two of the cases, the City of Toronto and in Ottawa, the supply of housing was a consideration in the tribunal determinations upholding zoning and I believe the licensing elements to the regime in both Ottawa and Toronto. So housing supply has been noted in two cases. So I just want to step back to that earlier comment that you had made. In terms of being the only determination and the consideration in the Ottawa condominium case under the Ottawa regime, there are quite a few cases that deal with vacation rental units, VRUs, STRs. I sort of have all the footnotes in the draft opinion that you've received. So there are many cases that address the issue and deal with the issue. So I wouldn't say there's only one, but there are quite a few.
That case characterized the use as being commercial. I'm just clarifying my question.
I believe AJ was still answering your question.
Oh, no, sorry. I do appreciate the clarification of the question.
Okay, go ahead.
Yeah.
Go ahead.
Doug, you say?
That's the only one I found that clarified the distinction that short-term rentals in that judge's ruling are a commercial use. Are you aware of any other case that overturned that? Or is that the law of the province right now?
I think what actually might be the most useful through you, sir, the chair. I think what will be most useful for everyone, and it's unfortunate the Oromadante decision by Member Vincent didn't clarify the commercial element in that context. Because there is leave by both parties are seeking leave, I suspect that issue may be determined in the forthcoming leave matter, I believe a divisional court upcoming pretty shortly, on the commercial element with respect to the Oro bylaw, which I think would be the most useful, frankly, for us collectively on that exact point. Because both parties, I'm aware, have raised that element of the decision and sought guidance from divisional court in an upcoming matter that should be heard very shortly and should have a decision fairly shortly. So I think that is probably will probably be a more useful, not more, but it'll probably be a fairly definitive statement, I expect, from divisional court, because the oral decision is seeking leave. If that answers the question through the chair.
Thank you.
Thank you, AJ. Any other questions for AJ? Okay. So we'll ask for a vote to accept AJ's presentation. Oh, favor?
Oh, sorry, who was first?
We had to move her in second.
Yeah.
We were having questions and then now we just. So thank you, AJ. We might be coming back for more questions to you throughout the meeting here. Anyways, I would like to take a look at options for, and maybe open it up a little bit to the committee for options for our specific township and what is most highest on the list, I guess, of issues that everybody sees is a problem with short-term rentals. And I think everybody can kind of agree that I've heard at the last meeting of most people, the biggest issue was noise, garbage, running of dogs. What other stuff is there, but maybe we could take a look so that staff can possibly prepare something for to bring back to the committee that we could all. So I'd like to move ahead and try and nail down the points that is affecting everybody and come up with something we could all live with and basically have staff then present that back to us that we can have basically a presentation back to council.
Is it thought, like, is there the provisions that are in place right now for animals, for noise, for garbage, for, you know, all these things that we already have policy, we have stuff in place, so I think we need to bring those up and see what we can adapt or how we, you know, what kind of scoring we do or something to provide the, you know, accountability for people, but we already have existing things. I think we all gotta be really careful that we don't want to overregulate ourselves to death here and put rules on the homeowners. And we have to remember too that rentals, the people that are renting a place, if there's 4 people in a house, whether they're the rental, they're there for a week, they're gone again. If there's a homeowner there that makes noise, that has their, you know, they're doing renovations, or they like their music, or they play the drums, or, you know, whatever. We don't want to regulate our neighbors and turn this into a, you know, a pushback situation where we don't have a community. We've just got a bunch of people that have zoned out, they're eked out what they want, and we're not looking at the broad picture of what, you know, what we're trying to do to provide a fair, level playing field for everybody, respectfully.
Right.
And I think the biggest thing is we need to respect our neighbors. So, you know, if people are gonna rent, then they need to take the responsibility to say, hey, I have a noisy situation, but I need to go and make amends, be responsible, or take the hit, you know, have some kind of scoring or something. But I think we also, you know, we have to look at what we have in place now and how we can enforce that before we need to bring in a bunch of new policy and then start regulating ourselves to death. So,
Well,
just
I guess maybe staff, maybe Alana can speak more to this better than I can, but correct me if I'm wrong, Alana. I think we can take a look at each individual bylaw and maybe strengthen, for example, a noise bylaw, that if somebody's being offended, is offending that noise bylaw, and that goes for, doesn't matter whether it's short-term rentals or whether it's for it doesn't really matter if you enforce that in the township, a noise bylaw. Well, that affects everybody within the township, and so it's kind of it's a whole township wide, not just short-term rentals that it's going to affect. Like
I
you
think
said.
that's why I say I just don't want to have everybody picking on the one or two problem cases, and all of a sudden it affects the whole township. And now everybody's overregulated because of a couple of people that didn't want to take responsibility. So there's ways that we can make them responsible, and accountable through that punishment or, there's gotta be ways around this.
Sorry, go ahead.
Sure. I think we discussed at the last meeting, we discussed about beefing up or looking at the bylaws and all of those bylaws, whatever nuisance bylaws there are. So if I could just sum up that, I thought that's what we were going to do, is look at those as a first step. And then possibly, and that's not targeting us as TRs, that's for all property owners. And then if we could start to monitor that, so we know how many of those are actually legitimate complaints against STRs or other property owners. I think we need to start monitoring things. That's just a suggestion, so that we can quantify what that really means for the township. But the other thing that, if I may, is that we don't have any quantified metrics for how many short-term rentals there actually are in this township. So that my suggestion would be that we need to probably look to some type of quantification of the STRs. And I've been looking at the Fort Lakes report, and they actually had 2 different companies that provided them with those statistics. If that's helpful.
Yes, I read that as well. Suzanne sent, sorry, can
Go
I?
ahead.
Suzanne sent it to me, so there was, and that's where Fort Lakes started. I mean, they started this process in 2018, so they're well ahead of us on that point. And I think that's an important point, because I know they've tried a lot of things and they've gotten to what they think is going to work for them. There was 2, the one that stuck out in my mind is called Host Compliance. And they actually offer, it's only to government entities, so I can't do it myself. They will offer a free assessment where they use basically AI technology to scrape the internet and will tell you pretty accurately how many short-term rentals are operating in your area. And they say it's a free assessment. Their business model is to then provide tools to help manage short-term rentals using technology, but the assessment gives you and you just have to contact them. I don't know exactly and how they do it. Or how they do the process, but they come up with this. And I think that's a good starting point to say, okay, this is what we're dealing with, because you can go on the sites and check and try to count, you know what I mean? But there's so many different kinds of the way people rent out. And so at least we have a number. And like Jeff said, I mean, to make people accountable, you have to know, is it a neighbor? I mean, is your neighbor having a party, or is it a renter having a party kind of thing? Is this a problem? Is this, and then you have a new, so to make people accountable, you need to know who's the actual operating and who's just your neighbor who happens to like loud music. I mean, there's no, do you know what I mean? Like that's normal, because you would just go over and talk to your neighbor. But if you have a new neighbor every week,
But at the end of the day, it's
becomes
the homeowner
problematic.
that's responsible, right? If he's renting it out, it should be the homeowner that's responsible and take the hit. If they, police have to be called because of noise complaints, but at the end of the day, there's a way of following up to that to make the homeowner responsible, but.
And on a high level, I agree with the way, because I'm not a big regulation person. I get concerned that I'm being drafted into managing someone's property because it's complaint based now. So it's on me to let them know that they're loud, that their dog's on my property, that there's garbage all over the road, and then hope, hope that they learn, because there's no, other than some fines, there's not a big repercussions. That's where I get concerned, is where do we make people concerned enough that they won't be able to rent anymore because they're continually violating these noise bylaws, because noise bylaws are end, it's just a fine, that's it. You get 100 fines a year,
We have to
and
be
then
careful
that's it.
with noise
I
bylaws.
agree.
You have to be so careful because, like, for instance, where you're located on the lake, you're only 80 feet across the river and there's a whole bunch of other houses. So now we've got 40 homes in a 10-acre area. Where you get over where I'm on Stony Lake, I'm in Hamilton Bay, there's 9 homes in my whole road. So the noise complaint, I can make a heck of a lot more noise in my place and not be obtrusive to anybody. Whereas in your neighborhood, someone could have a phone ringing on the deck across the way. If they, that could be something that disturbs somebody too. If, you know what I mean? Like, it's just in proximity to everybody. That's sort of the respect nature that has to be brought in. But it's really hard, if you start regulating, you're gonna put people in situations where they're persecuted because of just their proximity to the neighbor side, and we get some kind of pushback, all of a sudden, you know, there are busier areas than others, so, you know,
Yeah, no bylaws are so subjective. Because, you
I know, that's why we just gotta be careful not to over-regulate ourselves.
Doug?
I would like to go back to the basic premise. We have a planner here, we've got a great planning lawyer here. And it's my understanding in zoning bylaws, if you can't fit yourself into a bylaw, then you're not a permitted use. Any disagreement? STRs are commercial use. Agreement?
No.
We reside in shoreline residential areas. Commercial properties are not permitted. So it's not picking on them. They've interloped into our neighborhoods. I'm also a big believer in Jane Jacobs. I don't know if others are aware of her or not, but she was the author of modern urban planning. And when I attended Osgoode Hall, she was the visiting professor of residence. She was the first person that observed community and what destroys community. In her case, it's barriers, and in my mind, it's commercial operations in a quiet residential zone. You get interloping people coming and going, and it destroys the concept of community. So that's higher than dogs and noise in my mind.
Well, anyways, thanks for that opinion. What I'd like to do is go back to, I think we need to have a common ground to ask staff to come back with them answers.
Then I endorse Richard's request.
Sorry.
Yes,
So-
I have a second request when
Yeah.
I get a chance.
Okay, so what I'd like to do is have a common or a show of hands, basically, who is in favor of staff looking into enhancing the current bylaws that we actually have. That would be correct. Noise, nuisance like dogs, right? Dogs, nuisance, garbage, parking, again, for anybody that's, you know, inhibiting people's ability to get to their cottage because of short-term rentals. I heard that as well.
What, it's not a short-term rental, what?
Well,
Like, I got.
And it could be a neighbor, but we still need to maybe look at that bylaw. Maybe the current bylaw will be sufficient enough, but staff can take a look at that and come back to us as a committee and tell us what we need to look at strengthening. Sorry.
If I can,
Sorry, go ahead.
through the chair, just
Yeah.
our current bylaws, part of the challenge we have is the enforcement mechanism and the fines that are put in place. So they are updated. They do identify, you know, kind of that one liner that says you can be charged up to $5,000, you know, and it's not really an effective way to enforce. We're certainly not going to go out and ask everybody who makes noise to, you know, go to court over that. So we could take a look at those bylaws and try to put in some set fines, but there would also be an establishment. It wouldn't just be noise that, you know, irritates the neighbor. We would have to have some threshold and, you know, there could be some time set in, and that's something that we can look at as staff to determine what is in the existing bylaw, how can we put parameters in that to make it effective, and also look at those set fines, so that if there is a noise complaint and the OPP go out, there is, you know, a set fine that is laid at that time, and it's not something that we're going to court or establishing exorbitant amounts of money. So unfortunately, because our bylaws are dated, we don't have those set fines. So that's something that we could look at that might be helpful. And it wouldn't matter whether it was a short-term rental or somebody
Well,
that's disturbed.
And really, I think we need to approach it from, forget about the short-term rentals. This has got to be approached from a homeowner in this property, because that's what's going to affect. There's a lot more homeowners than there are short-term rentals. So if we're going to put all this policy and all these new regulations, you're regulating the honest people, and you're putting parameters on the honest people. So if we have people that own places making noise, they're going to be guilty regardless. So we can't always blame
If
it on
I
short-term
could
rental.
comment.
So So I think we need to look at it from a perspective of we're monitoring and regulating our own constituents here. And that's why we gotta look at it from that point of view, not just the rentals. And back to what you said, Doug, and if that's our policy, then people have to fall into that. Then the short-term rentals fall naturally into that same pocket as well, but the rules reflect everybody. So I don't want to be over-regulated. So I don't think anybody wants to be. So I think we just have to really be careful on seeing how we can push forward.
Sure. Doug, and then back to,
If I could first question, we do have a current bylaw. I do live in a shoreline residential zone. Why hasn't the bylaw been enforced by the township to restrict commercial uses intruding in my residential zone in the past?
You keep saying commercial, but that was what you said Ottawa said, but this hasn't been passed, so it's not really considered
No.
commercial.
Let me
Point
finish.
of order.
It is a commercial use, short-term rentals. They're operating in a residential zone. The only exception in our residential zone is a bed and breakfast containing not more than one unit. So why hasn't township enforced our bylaw?
Through the chair, in discussions with our current zoning bylaw, and part of the reason that we had asked Eric Burles to join us is because we're looking at those cases like Oro-Medonte, where it has cost that municipality thousands and thousands of dollars to defend a bylaw that was never designed to address short-term rentals. So it was never my recommendation to council to go back and try to find all the short-term rentals and start enforcing that zoning bylaw being subject to those appeals. So what we want to do, we do have a new official plan we are waiting on. We will be looking at our zoning bylaw, and I'm hopeful that we will have some case law at that time that we can look at our zoning bylaw. If something comes prior to that and this committee wants to, or council wants to have an amendment done to our zoning bylaw, we can certainly do that too. But in our discussions with our legal representatives, our current bylaw was not something that we felt was going to be enforceable. And if it was challenged, we were going to be subject to those legal costs and a process that we weren't prepared to enter into, or our staff was not recommending that we go down that road in the event that it's going to cost.
So it's a cost factor.
100%.
Oro-Medonte, and we have AJ here, is prosecuting a number of cases right now. And I assume Eric Burles is probably acting for the township. And I assume, like, AJ, you can elaborate more, but when might we start getting some feedback from the courts on these prosecutions?
Through you, Mr. Chair. That's a good question in terms of, Doug, as you know, the court's timing is tough to sometimes predict. But I imagine it likely will be heard in the fall or sooner. So we'd be looking at this year for a determination from the courts on the various prosecution attempts by Oro. I think that we'll have something this year, is my guess, is my estimation on the basis of our involvement.
Could you comment approximately how many cases they're prosecuting in Oro-Medonte at present?
I don't know offhand. But I can look into it if we have that information available. We are principally dealing with the leave and the appeal with respect to the amendment bylaw that added the 28-day exception or restriction on that element. That's what we're principally acting on. I don't know if we're acting on the actual enforcement proceedings, which are happening contemporaneously. So I think that we will have some form of judicial guidance on both fronts. I expect this year. That would be my hope or expectation, but again, that's out of our hands.
okay, thank you. Thank you. So I'd like to keep this moving so that we can at least have something to tell staff to bring back to the committee at the end of this meeting. So with a show of hands, who would like staff to look into enhancing our bylaws and bring that information back to us? Can we have a motion in that regard from one of the members, or? Sure.
So as a first step, if we could request, looking at the nuisance bylaws, to have them updated for all property owners. And if we could perhaps look at some kind of mechanism for monitoring those new bylaws with, if they become approved. Is that anything? Okay.
Okay. A seconder to that motion?
Yep.
No. No.
Okay.
Seeing nobody, I guess that motion fell.
Okay.
So, we're sorry. Sure.
I'd like to endorse Richard's suggestion and present a motion that we retain a third-party consultant to first tell us how many short-term rentals are operating in Douro-Dummer.
Well, it's a no cost and it's a quick call to this company. I don't think it's literally a free assessment and it's been proven to be relatively accurate and Court Lakes did use it. So I think it's a good starting point. And with your point, Jeff, is I'm not necessarily want to create bylaws for everybody. It's a short-term rental committee, so if they're the ones that are being loud or dogs or whatever, they're the ones that should be quote unquote penalized or held accountable for the behavior of their guests in the property that they're renting out. So that's why I'm kind of fudging on just upping noise bylaws and whatever for everybody when no one's really, it's again, quoting Jeff, a small number of short-term rentals that are the ones that are actually we're trying to get a grasp on here and making sure that everyone's accountable for the behavior of their guests and whatnot.
Through the chair.
Yes. Sure.
I think then I could amend that because what I'm suggesting is that you update all the bylaws for all property owners, but when you start to monitor it, then you can figure out which ones are the short-term rentals and which ones are the property owners that are living there. Like you can't, there's no process. We're just updating bylaws and then what are we doing with them? So like, unless you're starting to track it and you know how many complaints you have from the home sharing economy, it could be anything. Let's not call them STRs, any type of home sharing economy.
And sort of what's the context of updating them? Is it just increasing a fine? Is it saying, okay, we're going to lower the noise level of what we consider noisy? So that's why I get curious about saying, let's look at something that I don't really know the context of what we're looking at updating.
Okay, just back to Alana. Alana, I think you have some information. Maybe you've looked in the past for how many short-term rentals was in our municipality, or anyways, go ahead.
Through the chair, we did have a presentation that was provided to us and we did have a number. From my personal experience, looking at what they provided throughout the county, it didn't appear accurate, but I'm happy to go back and seek the information from that company and a free assessment. That's not a problem. With regards to the bylaws, if the committee wants to see staff come back, my suggestion is let staff go back and research that and propose something, as opposed to having a conversation about specifically what you want in these bylaws and then have staff come back and say, yes, we can, no, we can't. It's far better if we can look at what works in other municipalities and what we currently have in place and then propose something as a draft that you can then decide, I like this, I don't like this, and give further direction if necessary. So if you want us to look at the bylaws, we certainly can do that and come back to the next committee meeting with some drafts so that you have the opportunity then to look at something in front of you and decide whether this is something that you want to recommend to council.
And I understood it was because you don't have fee schedules now, so you would be proposing some type of fee schedule for those bylaws, right? For the nuisance bylaws.
Through the chair, yes, it would be what they call set fines. So when you draft a bylaw, and years ago, bylaws were always drafted, like I said, with that one liner that says you could be charged up to $5,000. But subsequent to that, as time went on, we would establish a set fee schedule, you would send it into the province, it gets approved at the provincial level, and it allows us to arm the OPP with that bylaw so that they can actually lay the fine where they can't do anything with the existing bylaw. So that's some of the challenges that we have with the current enforcement. We are small, we don't have a dedicated bylaw enforcement officer, we don't have someone to go out on a Saturday night and try to deal with these issues. So
to be able to look at those problems, which as we talk about short-term rentals, seems to be the first thing that people talk about, we really need to be able to put in some set fines. And we can certainly monitor them once we have them. We will get very specific numbers on calls and how many fines were given out. So it's something we definitely can do.
Yeah, I think that it's more productive if you're monitoring them and you can provide some evidence for how many complaints you have.
The province has recognized municipalities have the right to impose a 4% called hotel tax on the operation of short-term rentals. So it can be a revenue source to the township. As I understand it to the council present, the licensing fee can be designed to cover the cost of township and additional staff required to institute a licensing program. And that can be a self-funding program by the operators of short-term rentals. So in my mind, township can cover its costs of administrating the program and derive a revenue source, the same as you currently are receiving from legitimate resorts and tourist accommodations that pay taxes that double the residential rates. So I find it much more easy to endorse a system that we figure out how many are operating in the township, what are the projected revenues to the township from the 4% accommodation tax, and what is the budget from the township to set up a separate person to administer the program. You can divide that by the number of short-term rentals and figure out the license application fee. So it should be revenue positive to the township, not revenue negative. But we don't even understand that at present.
If I could turn it over to a Lynn on that.
Thank you, through the chair. I agree with you. It's not something that we've looked at, so that we come back to the committee, and if the committee wants us to look at a licensing regimen, then we'll go back and we'll bring that back to the committee. We certainly have not, at a staff level, looked at any kind of a licensing model at this time. So we bring that back. It was listed in the letter that was provided as an option. If that's something that the committee would like to see us come back with, we're happy to do that. That certainly will take us some time.
I would propose that.
Okay. The seconder to that? Sue, all in favor? Carried. Okay, that's great. We'll move on for the license. Sorry,
So moving forward, again, I think we need to concentrate on the existing bylaws we have there. And what if we were to find out the complaints and the guilty parties, the majority were actually homeowners, and it wasn't the short-term rentals that were the problem? Well, if we find out by regulating the whole township with the bylaws, we find that there's a very small problem with the short-term rentals because there's only a couple of guys that aren't running appropriately. So,
Mr. Chair, may I respond?
I was just going to finish.
Okay, finish first.
You know, to start jumping, we're getting a little farther ahead. We have existing laws and things at our hands right now. So I think we need to look at those and see what we can tweak before we start blanketing again and try to pick on. We don't know for sure that the noise complaints are definitely coming from just the renters. You know, you have a problem over by your place and in South Bay, but I mean, that's one big place and they have 25 people staying there. That's an extreme situation. But again, if our bylaws are strong, we can go to that person through the OPP and say, this is your 5th complaint, and we start doubling their fines, or we come up with some kind of a punishment that makes it not as opportunistic for them to run a business because they keep getting, heavily fined. We start off with some kind of monetary fine as a reminder, but then maybe it doubles, then it doubles. So by the time someone gets a 4th or 5th complaint, they're put into a situation, or we have a license that we can say that you're going to revoke them. But we have existing.
I'd like to go back to the premise. We're in a shoreline residential use. Short-term rentals are an illegal use in our zone. They are. It's an illegal, the Quebec legislation branded it illegal.
We're in Ontario.
Establishment.
We're in Ontario.
Then show me in the bylaw, our current bylaw, where you're permitted to operate a commercial business in a
Where does it say in the
residential
bylaw?
zone. We have our planner here. May I ask the planner that question? It's not a permitted use.
Through you, Chair,
So- Pardon me?
Go ahead.
just through you to the chair. That's correct. That short-term rentals, as we describe them, which are the rental cabins or rental cottages, are only permitted in a tourist commercial zone, not in any of our residential zones presently.
Correct. Thus, they're interlopers here. I can accommodate them provided they go through a licensing regime to regulate them. And a self-funding one, and something that does something for the township and generates an accommodation tax for the township. Right now, they generate nothing for our community.
Okay,
They're
that's
interlopers.
not true. Your point is noted, Doug.
Thank you,
We have, your point is noted.
thank you.
We have, it is passed, the committee just passed to ask staff to bring back a licensing, to look at a licensing,
Because they're in a legal use.
well,
If you
Again?
can't come out to driving a car without a license.
through AJ, I believe his recommendation is not to do that now within, I believe, our municipality. I mean, I don't,
No, I read AJ's letter and he sets it out very clearly without recommending, as I go through every township in the province, they're all leaning into licensing.
that's why we don't want to be in, at this point, until we have some recommendations for council, and that is why this committee is here. We don't want to go down that avenue and cost the township millions of dollars in legal fees.
Excuse me, how's it cost the township any money if we license? I don't think you understand
No,
licensing.
you're misunderstanding what I'm saying. And you're saying that it's illegal.
Yes,
You're saying that it's illegal.
it's an illegal use of present.
So we don't want to go and challenge that at this point until we have some regulations in place.
And I understand what you're
And
saying.
as the other municipalities that found themselves in that situation have done. Right? Correct?
I
understand.
I recognize totally what Alana said, that it's a cost the township can't bear.
Right.
But it doesn't change the fact they're an illegal use. And in my mind, the only way they become a legal use is if we license them.
No, I have a question for Elena.
Go ahead.
So is there a way without like leaving existing bylaws, because can you only attach fines to bylaws? Like noise, dogs, garbage. So for instance, if you did come up with a licensing model, and now you have, can the fine be attached to the license as an operator of the license? So that I can have, like, this is gonna sound, so someone that's a resident that's, you know, just there and you know, doing what they do at their house, maybe they have a big party once a year that everyone knows about. But the next door is a short-term rental where maybe they're having too many parties because it's people visiting. But they're actually going to get fined through their license because they're operating in a single family use property. You know what I mean? Is that, so that we're not putting, like Jeff said, we're just blanketing everyone else with all these because of some bad, you know, some bad operators and blanketing everyone with higher fines and the police showing up saying, this is, you know, a big fine for you just because you're having a big birthday party at your house, you know, once a year or something, versus saying, you know, but you've agreed to these terms as a short-term renter and paid your license, and as a short-term operator, paid your license fee and agreed to these terms that your guests, because they are visitors to our community, that they are going to, you know, conduct themselves in a manner that's reasonable. Kind of thing. So I don't know. I mean, that's why I'm asking that can be attached to a license versus changing the whole scope of everything in the county just for that. with the township.
Through the chair, like I said, we haven't looked at the licensing model, and maybe Jay can correct me if I'm wrong, but I would think if we were going to establish a licensing model, we would certainly have parameters in there that there would be an expectation on how that property would be managed by the owner, and there would be some sort of consequence if those parameters weren't followed. Specific to noise might be tough, but I think we definitely could put some things in there that would require the onus to be put back on the owner when we have those licenses in place. And again, we can do some further investigation. We're going to come back with a licensing model and we'll take a look at that at the same time. And perhaps if I need some clarification, I can reach out to our solicitor to determine what is reasonable and what we can enforce. Because essentially it comes down to the enforcement, and we want to make sure that we're being fair, and still, if we're going to put something in place, we want to be able to then follow up and enforce it. Otherwise, it's all for naught.
Sorry, Sue.
I think the thing is that if we look at the history of STRs and what municipalities have been doing over the years, some of them since I've been reading, some of them since 2018, and the progression has been that they've updated their nuisance bylaws. They've attached a fee schedule to that, but then they've moved on and they've looked at one that I read, they looked at all 444 municipalities in Ontario and have reviewed everything and seen what they've been doing. So those reports are available. It's not like reinventing the wheel. They're already there. So there's a lot of municipalities that are moving to licensing. I think I read 85 right now. So I mean, there's lots of material out there that has already been investigated. The reports are there. I think it would be wise to probably look at those as opposed to, doing a lot of research. It's like you said, we have a small staff. So, I mean, there's lots of information out there already. And one of those things is that almost all of them started by updating their bylaws. That was because when you get to the licensing, you need to have those because you've got open air burning, you've got dogs, you've got parking, you've got noise, you've got fireworks. There's all types of them, and those things need to be tracked. So, I mean, I think it's all connected, and hopefully we can come to some kind of resolution on how we can move forward with that, because I think that that's the model that's pretty much out there right now.
If I may speak to that point a bit further, if it pleases the chair.
Go ahead, AJ.
Thank you. That's a good point, because in a licensing regime, one element under the Municipal Act is the ability to impose conditions upon receiving a municipal license and the renewal of that municipal license. And a common approach in municipalities in Ontario is to take into account upon renewal or upon issuance the number of bylaw violations that you have had over a period of time. So if you have a strengthened set of bylaws and you have a series of charges pursuant to those bylaws, that is a fair and appropriate consideration as a condition of licensing or a renewal of a license. And that is a common approach for municipalities, if that may assist.
Thanks, AJ. Doug had a.
Hey, AJ, while I have you present, licensing is easily enforced too. It's my understanding that if you don't license, then the fine just gets added to the tax roll. You don't have to go to court for a breach and prove it. It's a reverse onus. I don't know if you've had more experience in this than I have. And the same with infractions. But you've got to lead us. Can they be added to the tax roll too? And it's up to the operator to reverse onus and try to get them off? Can you explain your experience with licensing?
Sure, Doug, if I may, I think that addresses a few areas of adding municipal debts to the property tax roll. So if I can break it down a little bit differently or deal with it in terms of licensing. So violations of municipal bylaws where you are charged with an offense, it depends if you're doing Provincial Offences Act offenses or you're doing administrative monetary penalties. And those are two different systems, but I think that the mechanics work differently depending on which bucket that you are in. But presuming that we're in POA and you go through and you do a set fine schedule that is approved by the court, and then individuals are charged, and those are convictions. So we get to the point at which there is a charge and there's a conviction. Those charges and those convictions translate to debts owing to a municipality by an individual. The municipality is authorized under the Municipal Act to add those debts onto a given property tax roll for an individual, and can enforce akin to unpaid property taxes. There's some nuance with respect to tax sales, but that's a bit more detailed of how you deal with that. And it's the same for the case for administrative monetary penalties. You said with the reverse onus, that is much easier in AMPs and administrative monetary penalties in establishing a reverse onus. You can put language for a reverse onus in a POA offense regulatory bylaw, but that's a little bit trickier because an individual can still come and argue their case in a POA, and there may be an obligation on the municipality to demonstrate and prove that an individual has violated the bylaw with an evidentiary basis. There have been municipalities that put in that reverse onus language into POA bylaws. I think they're more effective in the AMPS scenario, but in either scenario, if you charge somebody for violation of a municipal bylaw and that charge becomes a conviction either through attendance or non-attendance by an individual in challenging that bylaw violation, that can be added to the property tax roll and collected akin to the way that you would collect property taxes from an individual property. If that helps.
Thank you.
Thanks, AJ. Okay, so I guess we got consensus on the licensing. Zoning. Would we like staff to take a look at zoning and come back with something as far as the zoning? I think it might be kind of same as licensing almost and zoning, and we'd have to probably put that in the zoning bylaw for the licensing. And would I be correct in that?
For you, the zoning, I think if we were to look at anything with zoning right now, we would have to look at an amendment to our current zoning bylaw. Again, we go back to Oramadante, who tried to strengthen their zoning bylaw. It didn't really work, so I'm not sure that would be the path that we take, but we could look at other options within our existing zoning bylaw. The other option is to take a look at the licensing at this point, which I think in part is probably going to tie into bylaws regardless as we go through the process, but definitely take a look at the licensing and keep the zoning portion sort of on the back burner until the official plan is finally approved and we start to look at the new zoning bylaw. And by that time, my hope would be we have some case law, but we also could have some other things in place that might be assisting the municipality that will give us some clearer direction on what we want that zoning bylaw to reflect.
Okay. Okay. So have we thought about the enhanced bylaws again? I know we kind of got defeated there, but looking at it, but I think that's very imperative for us to look at that. What's everybody's feel on that?
We're talking about existing
Well, and looking at the bylaws and bringing them up to
500%. I think we should review them and see if
Look
there's
at-
things we can address that make it a little more stringent or accommodate some of these concerns that people have. So there's a little more, it brings more respect to neighbors, just, with dogs and things like that. But yeah, maybe we can address looking at the bylaws that we have existing and see if we can strengthen them.
So we all in favor of that? Everybody's in favor of that?
Did you want me to move that motion? If you could read it fine.
Yeah, did you want to read that motion back?
Do you have it?
That was defeated.
It was.
Oh,
But it
right.
sounds to me like
Oh.
people have kind of
Sorry.
changed their mind a bit on that with the consultation.
To review the nuisance bylaws, and other bylaws, and then put mechanisms in place to enforce them.
Like, and fee, yeah, fines.
And fines.
A fee schedule, whatever you want.
Sorry, go ahead. No, you want.
Yes.
we got a seconder to that motion.
Well, we've got the cart before the horse. We need to address the bylaws we have existing right now before we inflict any other things. So,
Well, we need staff though, Jeff, to bring that back,
right.
bring them. They kind of need to be done anyways.
No, I get it, yeah.
They kind of need to be done anyways. The bylaws that we currently have are kind of, some of them are very outdated and some are not. So I think it's not a process that we don't need to, I think I'm correct in saying that we don't need to maybe look at it, even as, even if this was not, committee was not functioning now. Am I correct in saying that, Amanda, that we need to be looking at it as a township anyways to be?
Well, I agree with that, but I think we need to look at those and see what we have in place before we decide to start imposing more fines and, and, address what we have now. And then move forward from there.
So everybody get a seconder?
If I can first comment.
So I want a seconder to the motion.
Otherwise, there's no discussion.
Otherwise, we're not discussing.
Okay.
Yep.
So
So a
I'm,
seconder to,
Yeah.
Suzanne moved it.
Okay, I'll second it
Yes.
for to review it.
Yeah.
Discussion.
Okay, now we can have discussion.
Okay, if I can comment, I sat on the planning advisory committee, in fact, that drafted the 1996-97 general bylaw. It took meetings one Friday a month for about 4 months with the township planner at the time, Daryl Tye, to actually review the general bylaw. They're not easy things to read and understand. So I don't think it's that easy a task, and I think you have to do it in the accompaniment of the township planner to understand the bylaws and how they work. That's from my past experience. It's not an easy task. With the new county official plan, I forget the time frame, but you have to bring your general bylaw and OP into compliance. But I think it's a 2-year span, isn't it? So I think you're going to be doing this anyways, but it's a major task to bring yourself into compliance with the new official plan. So to piecemeal it in the interim, I think is a foolish way of proceeding.
Sure. Go ahead.
Through the chair, I agree with you when we're talking about the zoning bylaw. I think we're looking at more of those nuisance bylaws right now. And if I could just ask,
Order.
if I could just ask Jay, when we are looking at that licensing model, if we're gonna put provisions in there and you talk about adding things to the tax roll, based on our current bylaws, we are not under the administrative penalties program, the administrative monetary penalties. Is that something that we would likely have to do to be able to enforce those bylaws regardless? Because I don't, and I know I haven't given you our existing bylaws, so I'm putting you on the spot a little bit, but I understand you probably know what they look like if you've reviewed others, they're dated. Is that something that we would be able to roll into that licensing model, or are we going to have to look at them anyway?
So you don't need to move to administrative penalties to improve the existing suite of regulatory bylaws. Nuisance, noise. I'm thinking of nuisance and noise particularly as two of the key bylaws. Alana, to your point, the bylaws historically had that provision to say that the fine may be up to $5,000. And the practical challenge associated with that type of provision is it's like a 2 or 3 step process for the prosecutor. You have to go lay the information, go back to court, determine what that fine would be, and then issue the fine. That's what makes it difficult. And you can improve that through getting a set fine order from the court, delineating each of the offenses existing in the bylaw. So you can strengthen the existing bylaw. For example, with noise, you can add a specific threshold level for decibel levels at a certain time of the day. I haven't seen the bylaw again, but I imagine it doesn't have that. That is good because it allows you to have an objective measurement where prosecution is much easier. So it was above this decibel level at 11:30 p.m. at night on this day of the week or any day of the week. You have a good evidentiary basis. You have a pre-existing set fine order in advance that's on a schedule to say this is the dollar value fine. This is how it escalates over time on subsequent offenses for the same activity or action. And you can do that in the Provincial Offences Act approach through a set fine order. Administrative monetary penalties is a bit of a bigger undertaking because the purpose of that regime is to allow municipalities to opt out of the provincial court system to run essentially their own court process, where you come to the municipal town hall office to get a screening, and then the municipality can establish its own hearing officer, retain its own hearing officer, run its own process. It's commonly done first for parking, and then it's been expanded to other municipal bylaw offenses. So one doesn't negate the other. You can still strengthen your suite of regulatory bylaws and modernize them within the POA approach. And then further to that is administrative penalties, but that might be biting off a big amount to chew. If you're going straight to administrative penalties, you may want to take the step of viewing the historical bylaws, improving them through a set fine order, so that you can skip the 2 or 3 steps for the prosecutor to go through and lay the information and then ask the court how much the fine should be and then issue the fine. You can make that more efficient through a set fine order.
Through the chair. Thank you. That's more what I meant going through the set fines. Sort of outside of this committee, I can let you know that the city of Peterborough is setting up an AMP program, the administrative monetary penalties. They have had discussions about the municipalities being able to leverage that, so we wouldn't have to have our own hearings and have that kind of organization to be able to enforce them. We're not quite there yet. So I think if we're going to look at the bylaws, it probably makes more sense to put in those set fines right now as opposed to what is currently in place, so we don't have that 3-step process. If we're going to regulate short-term rentals through licensing, and we're going to establish, there are the requirements for noise and anything else that we can look at for bylaws. So we can certainly just bring the bylaws back as they are, but I think that will end up being discussion about what everybody wants to see. So it's probably better if we come back with some kind of a draft so that the committee can then discuss if it's something that they're interested in conjunction with the licensing program, and we can look at what makes sense.
Skipping to the licensing that you're going to look at, I strongly hope that you're going to look at the accommodation tax, because one of the things it does is it puts everyone on an even playing field. So, I've talked to people that are working in that industry, and they complain sorely about there not being a level playing field because they're paying the accommodation taxes and the STRs are not. So I think it's an important point to look at. Yeah, and as Doc said, it gives you a revenue stream also. Thank you.
Jeff, you know how many people are taxed enough in this country as mayor?
Hotel and resort
Another 4%,
owners
so
pay
you're paying income tax of 30%, plus a 4% of another accommodation.
Hold on, we have a motion up, so we have a motion on the floor. So if we can move on with that motion first, and then we'll come back, Jeff. So all in favor of that motion? Can you reread the motion, sorry?
That's a good idea.
Reread. The motion is,
To review bylaws before imposing fines. I believe that's what Jeff.
So I think it's back to Suzanne.
yeah.
Oh,
Suzanne-
back to
Suzanne.
Yeah,
Suzanne, yeah.
it's mine that are.
Okay,
And-
a motion to review the nuisance bylaws and put mechanisms in place to enforce them with fines.
And Jeff seconded that, and all in favor? Or sorry, Rich, I'm sorry, Richard, all in favor of that motion?
Seconds.
We have a. Okay, carried. I was looking up, to see if Nina was, were you in favor of that, Nina? I didn't see you yet, okay, thank you. Don't worry about that. Yeah, okay, and so we can remove this one, right? Because we're all on the page. I think we're all in agreement on the zoning, waiting for that process to take place and know what's, well, as Atlanta had expressed why, we're gonna see some outcomes here in the next little while. And hopefully when it comes time to our zoning will be accompanied or accomplished by waiting. I think everybody's in agreement on that, I believe so.
I just don't understand what you're saying on that one. Repeat it so I can
So, well,
understand.
Doug, you said it wasn't advisable for the timeline to change all of that. It's better to wait until the OP comes in.
I concur with that.
Yes, you understand what I'm
Yes.
saying?
Yes.
Yeah. So we're going to remove the zoning off the table for staff?
Yes.
For now, yes.
Okay. Okay, that's great. So we got licensing, enhanced bylaws, and I think that's pretty much it. Is there anything else? Oh, sorry.
Did we, I thought we approved Richard's motion, didn't you? Wasn't there a motion to have that company look at the?
Yeah.
Yeah, so okay. I
It
just
was
wasn't,
incorporated with the licensing.
Sorry, incorporated with the license, yeah. Yeah, so I think, is there anything else I'm missing? No? No? Anything, anybody else have anything else they want to bring up? No? Nina, you're all good there? Anything you want to bring up? Sorry, lots of times I'm looking back and forth to make sure I'm trying to follow you.
Thank you.
Okay, anybody else have any other new business? Seeing none, our next meeting date, I will turn that over to Alana.
So we put to be determined at the meeting, only because just to see what staff is gonna be tasked with. So maybe if you just give us the week or so, we'll take a look at the workload and then we'll send out a doodle poll. It seemed to work the best and get a response. I am anticipating we're probably early August by the time we come back. So we'll try to give lots of dates. So if people have holidays booked, we can make sure that we find consensus.
And thanks for everybody coming to the council chambers today. I believe it's very beneficial for myself. It's when it's online, again, it's very hard to see who's talking. Anyways, thanks for coming to the council chambers. Hopefully the next meeting, most of us can come. Thanks for joining us, Nina, today online. And thanks, AJ, and thanks, Christina, for all your help today. And with that, I'm going to ask for an adjournment. A mover and a seconder, Suzanne and Dave? Richards, right? Sorry. Anyway, yeah, so all in favor? Thanks a lot, folks. I apologize, Richards. Okay.
Sorry, I didn't get it.
that's right.
I don't know why I have Dave on.
I gotta go to.
I apologize. See you later.
He has a whole.
I'm also
lane
good with
of
fish.
lilacs. Whole lane of-
Yeah, they're all awesome. Well, we got made
So
some.
they're having
progress, I think.
sangria in the lilac lane.
Okay, yeah, sounds like that.
It sounds like fun.
Yeah, absolutely. Yep, I agree.
Okay,
Okay, thanks.
Thank you, everybody.
Thanks,
Thank you.
folks.
Thank you.
have a good long weekend.
Okay, have a great day.
Bye, everyone.
Bye, thank you.
Have a good day.
Okay.
Thanks.
Do you line up for a minute? We're still recording? I'm walking.
You know, we're gonna have to. Oh, and it's on this.